Hello, everybody. It is I, the Grouchy Historian, just letting you know, sit down, strap in. Here we go, week 5. We're going to get to the most controversial topics of all these last 2 weeks. You ready? Here we go. This week, we're going to talk about 2 of the most divisive, controversial, still argued about cases in Supreme Court history. Both of them passed within the last 70 years, right? Roe versus Wade was decided 50 years, technically, I guess. Roe versus Wade was decided in 1973, and the other case we're going to look at is a case, probably haven't heard of it as such, but you probably know the effects of it. Case called Obergefell versus Hodges, decided in 2015. It's the case on gay marriage, same-sex marriage, whatever you want to call it, right? And these cases, again, get to some very fundamental, non-legal questions. Let's be honest. When does life begin? What is the right to privacy? We're going to talk about that quite a bit. And who decides what marriage is? All right, let's start with abortion, right? As for anybody who's followed the court or as of course has paid attention to this issue, there have been almost yearly cases on abortion rights, abortion restrictions, the abortion issue since the Roe versus Wade was decided in 1973. So Roe versus Wade was the landmark case where the Supreme Court, depending on your point of view, and on these particular last 2 weeks, you might get a little more of my point of view, but I'll be very clear of pointing that out. Particular point of view of this so-called right to privacy. Now, this is a highly controversial, often discussed topic among constitutional lawyers, right to life advocates, pro-abortion advocates, is the right to privacy. Keep in mind, though, that there is no such thing in the Constitution as the right to privacy. It is not mentioned anywhere in the Constitution or the Bill of Rights. But Justice Blackmun, who wrote the majority of opinion in Roe, sort of was stitched together various articles of the Bill of Rights to come up with this notion of the right to privacy. Okay, that, you can make certain legal arguments about whether that's a valid argument or not. But the other thing that he did was, of course, this was decided in 1973, and we have had 50 years of medical progress since then. They seem to have picked, at least to me, this random notion that abortion should be legal until the 2nd trimester. Now, of course, we now know that with advances in medical technology, that premature children have been born at really just shocking stages, right? Very, very, very premature and have lived. So the idea that we get into this argument that is usually brought up when there's a case dealing with abortion is fetal viability, right? When does a fetus become a person, right? This is the fundamental argument. When does the fetus become a person? And of course, as Catholics, we believe that life begins at conception. And of course, a great many of our Protestant brethren and Jewish brethren believe this as well, and other religious groups, right? So this is one of the fundamental arguments raised in this case, is when does life begin? When does human life begin? And what is the notion of viability? And is it a valid notion to determine when life begins? The very specific question that the court answered is, does the term person as used in the 14th Amendment include the unborn? And at the time they ruled no. This has been the most controversial part, I think, of the ruling, is that basically unborn are not citizens, because remember we talked about citizenship quite a bit. Who's a citizen? What rights do citizens have? When we talked about Dred Scott and Plessy versus Ferguson and Brown versus Board of Education, they basically said that the unborn, preborn, do not have 14th Amendment rights to equal protection under the law. Okay. However, again, here's a bit of honesty. People don't really understand what the effects of overturning Roe versus Wade would be. Some people say, well, of course, as soon as we overturn Roe versus Wade, abortion would be outlawed. No, that is not correct. Originally, before Roe versus Wade, states passed their own laws regarding abortion restrictions or abortion rights. Okay, it was left up to the states as was specified in the 10th Amendment of the Constitution. Again, there is no right to an abortion in the Constitution, whatever the pro-abortion lobby may say. There is no, so it was left up to the states, often to the voters, to determine what restrictions they would or would not place on a woman's right to abort her unborn baby. That would be the practical effect of Roe versus Wade. Again, this is why I will now opine a bit. It is so important for the pro-abortion lobby to fight for Roe versus Wade, because likely in great part, large numbers of states in the country, they could not make the political argument, the moral argument to keep abortion legal. Therefore, they depend on Roe versus Wade to override any state restrictions on abortion, which is what many of the follow-on cases to Roe versus Wade were about, is particular states trying to impose restrictions on abortion. We are going to see in the 2021-2022 court year, yet another challenge to Roe versus Wade, given the fact that nominally, and I say that nominally, there are more, quote, right-leaning judges on the court than there have ever been, another challenge to Roe versus Wade. Now, my understanding is, looking at just some brief overview of this case, that again, this is not intended to overturn Roe versus Wade. What it is intended to do is restrict abortion to the first trimester only, right? The other thing that has come out of Roe versus Wade that is much more controversial and was certainly not intended, I think, by the original ruling by Justice Blackmun is the whole issue of whether the federal government should pay for abortions, taxpayer-funded abortions, through Medicare, Medicaid, or forcing private health insurers to include abortion as part of their, quote, healthcare package, unquote. Again, opining here, this is a hugely controversial, and I believe, in my opinion, much less defendable aspect of the abortion rights or restrictions argument, is whether we as taxpayers should have to fund them. That will be for you to determine as you do your research in the fourth quarter, because we will come back to this topic, because it is a huge topic that you, my fellow students, will face as you move out of high school and go off to college and beyond. You will have to decide where you stand on this issue, because it is not likely to go away anytime soon, okay? The other case that we look at is Obergefell versus Hodges. This is the gay marriage issue. So for those of us who remember, back in the 1990s, President Bill Clinton, irony of ironies, passed a law called the Defense of Marriage Act. It was meant to stop, because at that time in the 1990s, there were some states that were passing laws allowing gay marriage. Now, there's this whole discussion, and I'm not going to get into the whole legal ramifications, because again, this is a whole area of the Constitution that is still hugely, a constitutional law that is still hugely controversial, of the whole issue versus civil unions versus marriages, right? Suffice it to say that there was a law passed in the 1990s called the Defense of Marriage Act that was meant to specifically, interestingly enough, override part of the Constitution that says there was full faith that a law passed in one state was to be respected in another state, right? So if you received a marriage license as a gay couple in California, you can move to another state and expect that the state would respect your legal rights as a married couple for wills, property, power of attorney for healthcare decisions, things like that. A lawsuit was brought to challenge the Defense of Marriage Act as being unconstitutional under the 14th Amendment, and was decided in 2015 in favor of the defendants, that said, indeed, the Defense of Marriage Act was unconstitutional in terms of the Equal Protection Clause of the 14th Amendment, and that same-sex marriages would now have to be recognized across the country. Now, this is of course one of those, again, I will opine now a little bit, those slippery slope cases that began as a pretty straightforward concept of equality, equal civil rights, equal protection, and has now become a little bit more than that. And again, I will leave that up to you to discover and discuss when we get into the fourth quarter and revisit this issue. But from a legal point of view, what I want you to look at this week for both of these, okay, because again, these are probably two of the most controversial cases that we will look at this quarter. And I think it's important that you look at these from both sides and examine both sides of the arguments, because in order to form your own opinion, you need to look at both sides, right? Because if nothing else, in order to stand your ground and defend your opinion, you need to look at what the other side is going to argue in favor of their opinion, right? This is how logic and rhetoric are done. You research your point of view, you seek to understand the other person's point of view, and you seek to persuade as opposed to harangue them. And if you agree to disagree or you can't come to an agreement, then you simply have to walk away and stand your ground. And it's going to be very tough because these continue to be and will likely be for a very, very long time, forever, very, very controversial Supreme Court cases and very controversial situations, okay? So I have given you my opinion and a couple of things. I want to see what your opinion is, and I think your instructor does too, because these are things that are going to be have a real life effect on you when you go off to college and as you form your own faith of how you're going to stand on these particular issues, okay? But in order to have an opinion, first you have to have the facts, and the facts start with these two court cases, okay? Next week, we're going to end up with guns. That's right, firearms, guns, the right to keep and bear arms. Yep, that's what we're going to do, okay? Thank you very much. We'll see you next week.